I'm Mike Ajachi, and this is Burden of Proof, where we'll be covering high-profile cases. And today, the prosecution called its final rebuttal witness in the Lindsay Clancy trial. And in the Tupac murder trial, police revealed newspaper clippings about the rapper that they found in the defendant's home. I'm joined by two illustrious lawyers. To my right, criminal defense attorney Brian Buckmeyer. Brian, I'm liking the color blocking you got going on here.
We're trying to mix it up now. But it's interesting. With Clancy, I think we're getting to the end of this kind of battle of experts as we're just kind of ramping up with the Tupac trial. So it's interesting seeing how these both play out.
Yes, we're getting there. And to my left, criminal defense attorney and former prosecutor Bernarda Villalona. Hey, Bernarda. How you feeling today?
I'm okay. I'm seeing prosecutors putting into work across the board, from Clancy to Tupac to Little Dirk. There's a lot going on.
Yes, we have a lot to talk about, and we're going to get there. But before we get into all the legalities, the defense tried to cast doubt on the expert witness for the prosecution in the trial against Lindsay Clancy, who killed her 3 children. A forensic psychologist testified that he believes Clancy did not experience an episode of psychosis, but she did believe at the time that she would prevent her children struggling by killing them. But defense attorney Kevin Reddington pushed back on his credentials. Take a listen.
I stand corrected in one regard, sir. This morning I started off my questions by asking you about 49 years ago when you published an article on postpartum psychosis, and you agreed. You were in college or something. But in fact, it was not postpartum psychosis. It was about schizophrenia, wasn't it?
Now, Clancy's lawyers
say 49 years, but I think that's right, yes.
Transcripts of interviews with 32 schizophrenic patients, 15 male, 17 female, all with primary or secondary paranoid symptomology, were edited only to delusion-relevant material. Does that refresh your memory, sir?
It does.
Okay, so it wasn't postpartum psychosis. You've never written about postpartum psychosis, right?
That's right.
All right, Clancy's lawyers say she suffered from postpartum psychosis and should not be held criminally responsible. Let's bring in Rena Roy, who's outside the courthouse in Massachusetts right now. Rena, thanks for joining us. Now, what did the prosecution seem focused on with these final witnesses?
Yeah, Ike, today for prosecutors, it was all about trying to poke holes in Lindsay Clancy's postpartum psychosis defense. Jurors spent most of the day listening to a forensic psychologist named Kirk Heilbrunn. He was hired by prosecutors and interviewed Clancy for 3 days as part of their case against her. Today, he said plain and simple that he thinks that she should be held criminally responsible because he believes she was not experiencing postpartum psychosis at the time of the killings. He says that she justified killing the children out of love because she wanted to die by suicide and did not want them to grow up without a mother. But Clancy's defense attorney tried to cast doubt on his testimony, as we just heard right there, highlighting his lack of experience with treating postpartum psychosis. Heilbrunn himself acknowledged the last patient that he treated that was experiencing that condition was all the way back in 1982. He also told jurors that he was paid more than $50,000 by prosecutors for his work in this case, Ike.
And Rena, what do we know about closing arguments, and how soon could the jury really start deliberating here?
Yeah, so things did get pushed back a little bit today because testimony ran longer than planned. We are expecting the prosecution's final witness to be back on the stand tomorrow morning. That is a senior psychiatrist with the FBI. From there, the prosecution will rest their case. Closing arguments could begin as early as Thursday. The judge saying that deliberations could also start that same day, Ike.
All right, Rena Roy, thanks a lot for that. Now, for more on the Clancy case, let's bring in David Glass, a family law specialist with a PhD in clinical psychology. David, thanks for joining us. Now, Clancy is using what's known in Massachusetts as a lack of criminal responsibility defense, which is also called the insanity defense. So what do you make of that strategy in this case?
Essentially, it's the only strategy that the defense had. The killings were done. She jumped out the window. She admitted that she had killed the children. So the only defense she had was the insanity defense. And she had suffered from some mental illness problems for quite some time. So you could start to build a case that would support the lack of ability to commit these crimes.
So what's needed then for an insanity defense to work?
You need to have a mental illness that's been going on for some time. You need to be suffering from those symptoms consistently on a day in and day out basis. And you need to be suffering such that you cannot tell the difference between right and wrong. You either do not understand the wrongfulness of your actions, or you have no control over yourself, so you can't stop yourself, even though you know something is wrong.
Now, we've been hearing from experts who've reached very different conclusions about Clancy's mental state. How does the jury decide which expert's assessment is more credible?
The juries have to listen to the credentials of each of the experts. And I think, especially in this case, the difference is between treating psychologists and forensic psychologists and psychiatrists. Treating psychologists are bound to believe what their clients tell them and then to treat them accordingly. Forensic psychologists like Dr. Heilbrunn come in completely neutral. They interview, they review all of their psychiatric records to see, has there been a consistent mental illness problem? Has there been psychotic elements and symptomatology? And I think in this case, the jury should more heavily weigh the forensic experts.
Now, after everything you've heard so far, which side do you think has more work to do in their closing argument?
Well, ordinarily, the defense has more work to do, but this case is a very close case. There are compelling reasons on both sides. I think that the defense is going to have the harder position because Lindsay acted in a logical way on the day of these deaths. She sent her husband out. She had errands to do. She was taking care of the kids for weeks at a time. And then she claimed she had a sudden psychotic incident. That just doesn't fit with the way psychosis works.
All right, David Glass, thank you for your perspective. So what strategies could both sides use in this trial? We're going to find out in a segment we're calling Lawyer Up. So let's bring back Brian and Bernarda. Brian will be giving the perspective of the defense, and Bernarda over here will handle the prosecution. So Bernarda, I want to start with you, okay? So prosecutors right now, they're trying to cast doubt on the argument that Lindsay Clancy was going through psychosis by having an expert testify that she only heard voices in her head once. So how important was this testimony to the prosecution's case?
Well, it was very important to the prosecution case. And remember, they're adding on and building on to what's already been presented in their case in chief before they had rested. And now just these three experts that have testified now is to rebut what the defense put forward in terms of their experts. When it comes down to closing arguments, the prosecutor is going to have to emphasize on this timeline. And I think they also have to acknowledge and show some empathy in terms of that Lindsay Clancy was suffering from a mental illness and stop running away from it. Because if you continue to run away from it like they're doing now, I think they're going to lose the jury. I think also what they're going to have to focus on is timing and take the jury back to when they went on that jury view. Remember, this jury was taken to the scene of the crime, to that house. So they walked through that house. So they were able to see in terms of the steps that Lindsay Clancy took to get her kids to the basement, and from the basement to go up to the kitchen, and from the kitchen to go up to the bedroom. But before going up to the bedroom, guess what happens? Husband calls. She misses the calls and she calls back the husband, and the husband says that she seemed fine. So focusing on that testimony of that phone call, because I think the husband gives the most important, valuable piece of evidence in this entire case, because he's the only person that either saw or spoke to Lindsay Clancy shortly after the killing of these three kids.
Okay, so they're focusing on that, but Brian, the defense, they're doing something else. They're trying to discredit. We heard Kevin Reddington, the defense attorney, push back on the prosecution's questioned psychologist by saying that, hey, listen, your experience is a little faulty here. So in terms of the defense trying to discredit the experience of an expert, is that strategy that one that you agree with should be used here? And two, is that even effective?
Oh, absolutely. You'll see it with lawyers, and there are different sayings that come up where one of them comes to mind is like, if you don't have the law, then you argue the facts. And if you don't have the facts, I've heard then you pound your fist on the table and scream, right? But I think in this situation, where you don't like the conclusion that an expert has come up with, you argue the process. You argue how you got to your conclusion is wrong, therefore your conclusion must be wrong. And I think Reddington did an amazing job in the clip that we saw just earlier. I think he did it on purpose, where he's like, I want to apologize. We thought that you did a book on postpartum psychosis, and you agreed, but it's wrong. You did it on schizophrenia. And then he started listing all the things and what he did. And it's like, it's very clear that he researched this. And so I think in the end of the day, you're looking at this witness and be like, you don't even know what you wrote about 50 years ago. You're saying you wrote about this that we're talking about, but it's something completely different. Why should we trust you?
But that's why the prosecutor is just going to jump back to all those treating physicians that treated Lindsay Clancy prior to January 24th of 2023, but especially the testimony of the person that she saw, the treating physician that she saw the day before, even though it was a virtual visit. But the day before Lindsay Clancy committed these 3 homicides, she met with this physician. There was no mention about suicidal ideation or wanting to harm her kids. She didn't see anything that came up as a red flag.
But Bernardo, how do you prepare these witnesses for their credentials to be poked at, like the defense is doing right now?
So in terms of what happened in terms of the cross-examination of the 3 experts that the prosecution put forth, I'm going to blame it on bad preparation. The prosecutors failed to prepare these witnesses because they failed to prepare these witnesses in the sense that Dr. Heilbronn, who testified, he has had this case for about, let's say about 2 years or so. He didn't evaluate her until this year. So you've been sitting on these files and decide to evaluate her shortly before the trial is about to commence. So you did that to yourself. That goes in bad preparation. And now it's either you don't call him to the stand or you do call him to the stand and just deal with the hiccups that you're dealing with and have to deal with it in closing argument. But why build a hurdle when you don't need it?
All right, Brian, you heard that. Closing arguments, that's expected on Thursday. You're the defense. What are you going to do to get ready for that?
Not have a lot of sleep, probably one. But you have to think about it this way, right? Prosecutors always get the first word and the last word, right? They start off with openings and the defense goes afterwards. Then when it comes to closing arguments, the defense actually starts the closing arguments and then prosecutors get the last word. So with that in mind, I've got to play both offense and defense, right? Especially because there are 2 different arguments here and 2 different burdens. In one part, I'm going to make the argument of they didn't prove that Lindsay Clancy intentionally did that. That's me poking holes in an argument that they have the burden of proof. They didn't give you enough information. They didn't do this. Now, for the lack of criminal intent or insanity, I have the burden. I have to build up an argument and build up a case while also poking holes in their desire to poke holes in my case. I've got to do both, and I've got to do it well enough that when I'm done speaking to the jury, they are so irritated and angry at the prosecutor, but by the time they get up, I want lasers coming out of their eyes, and I want their ears closed because I know I don't get the last word.
How are you handling those lasers, Bernardo?
I'm going to be prepared. I'm going to be prepared from the very beginning. That's why I'm going to tee this up. This is something that I'm going to expect. I mean, a great trial attorney sees the angles from all angles, see the views and what's coming and prepares for it from the very beginning.
Pearls help too. You kind of like block the lasers and stuff like that.
It's on the wrist today. All right, Bernardo. Brian, appreciate you. Stick around. We obviously have more. Next, the prosecution presents new evidence in the Tupac murder trial. What investigators say they found inside of the defendant's home. Welcome back to Burden of Proof. Let's focus now on the Tupac Shakur murder trial. Las Vegas prosecutors introducing newspaper clippings about the rapper's murder that were found in a search of the defendant's home. Duane Keffe D. Davis is charged with orchestrating Tupac's murder in 1996, and he's pleaded not guilty. Let's bring back Brian Buckmeyer and Bernardo Villalona for this. Bernardo, what's the strategy behind showing these press clippings to the jury here?
They're trophies. What the prosecution is going to be arguing is that Keffe D. Davis had these press clippings from 1996. I mean, we're talking about 20, 30 years ago. And he had them as trophies, as memories for what he did on that day, his involvement on that day. Because why else will you have these press clippings? Are you a fan? We know you're not a fan of Tupac. I mean, I have press clippings of when Barack Obama became the first black president, but I don't have press clippings of any crimes. Like, people won't normally just keep that unless you want that memory of, look, this is what I'm proud of.
All right, Brian, how do you poke holes in that, in what the prosecution is saying?
You know what trophies are? Actual trophies. The gun, the shirt he was wearing, things that he had on that day that would remind him of what actually happened. Press clippings are not trophies. It's Tupac Shakur.
He had it in a photo album. In a
Sure.
scrapbook.
Sure. And I'm sure Keffe D does a lot of scrapping. That's on his Pinterest board. Like, that's not who he is, right?
But it only has of people that he has killed.
But Brian, it's true.
That's
Where
the
these
only
press keep,
scrapbooks
Where are
he
the other
has.
people that he
They
killed
were-
then?
they were-
Show me other ones then. Show me the other trophies that he has of other news clippings of other big things that he's done. Or could this be one of the biggest, most prolific deaths that we've seen in rap between Biggie and Tupac, that he's like, hey, like so many other people, I mean, we're doing a show about it. Like, why are we talking about it? Why are people watching? It's a big thing that happened in his life. He was there in some way, shape, or form, but that doesn't show or answer the direct question as to whether or not he participated in it. Prosecutors are stretching. And sometimes you stretch and you miss, and that's where the defense has to capitalize.
You just never know what piece of evidence is going to stick with a juror. So the prosecutor is going to use anything that they're able to get to, again, try to connect Keffe D. Davis to the homicide of Tupac Shakur.
Now, the prosecution is using Davis's own words from the interviews, obviously the memoir that he wrote. You're trying to point out the inconsistencies as the prosecution. So when you see the two different stories that are coming out here from what Davis is saying, from what he wrote now, how do you essentially tell the difference between that?
So in terms of first off, there are some minor inconsistencies, I would say, between the statements that Keffe D. Davis has given, from the proffer agreement to both proffer agreements to when he was brought down initially before the proffer agreement to his interview with Death Row Chronicles and Murder Rap and all these, anyone he told a statement to. You see what the major points are. The biggest picture here is, was he in that vehicle? Is he the uncle of Orlando Anderson? Was there a beatdown of his nephew at MGM? After that, did they go looking for Tupac and Suge Knight? Ultimately, did they roll up on Tupac and Suge Knight? And did someone in that vehicle start firing? But right before firing, Keffe D. Davis produced the gun to actually fire at Tupac Shakur. Those are the major points, because there's going to be a jury charge, and Brian is well aware of the jury charge when they're talking about inconsistencies. Is it something minor, giving time and giving different pieces of evidence that you can put together, or is it something major? If it's something major, you evaluate it differently.
All right, how are you handling the inconsistencies, Brian? Is there a way you can use that to your advantage? What are you doing here?
So as defense attorneys and prosecutors, we speak out of both sides of our mouths, right? If I was a prosecutor, which will never happen, what I do is I focus on big picture, right? Look what Bernardo just did. She talks about big picture. As a defense attorney in this situation, I'm going to talk about the little details. And then in jury selection, I'm going to pose it as, how do we tell if someone's telling the truth or a lie? Because I can tell you a big story multiple times in the same way. My son and I went fishing with my father. It was a sunny Sunday. It was 72 degrees out. He was wearing blue, I was wearing black. And then if I tell a story another time and it's different colors and it was not a sunny day, but we still went fishing, am I telling the truth or am I not? A prosecutor is going to tell you big broad strokes mean you're telling the truth. A defense attorney is going to say, you've got to look at those little inconsistencies in those little things, because that's how you know someone's lying. We talk out both sides of our mouth.
All right, we'll see what the jury thinks. Bernardo Villalona, Brian Buckmeyer, thank you very much. Next, the latest from the Lil Durk trial. While the prosecution says a credit card transaction proves the rapper's involvement in a murder-for-hire plot. All right, now to On the Docket, where we look at other high-profile cases. Instagram chief executive Adam Mosseri testifying today in the high-profile federal trial, pitting the state of California against Meta as a judge and jury weighs whether the social media platform is intentionally addictive and harmful to children. Meta says there's no proof social media is addictive. And federal prosecutors presented evidence on alleged messages between Lil Durk and his associates. The rapper is accused of orchestrating a murder-for-hire plot to kill fellow rapper Quando Rondo, but someone else was killed in the chaos. Prosecutors say the messages show the rapper telling a man named Jason Smith not to buy any flights that could be attached to him, but Smith allegedly bought them using a credit card attached to Lil Durk's music management company. Lil Durk is pleading not guilty. All right, let's bring back in Brian and Bernarda. Bernarda, the defense said the credit card charges could have been from anywhere. So does that poke a hole in the evidence big enough for the prosecution to worry about?
No, not at all. It's one of the building blocks that the prosecution is putting forth. So they're adding that in to tie in Little Dirk to this conspiracy. So when you add that in and build in that you're going to have the cooperators testify against him in terms of what was his involvement in this whole hit,
right?
And also attach it to what they get from social media messages and then text messages, they'll be able to corroborate that testimony. They'll be able to corroborate and put more focus on that purchase using that credit card. But that credit card, number one, does tie him in. But in a bigger picture, when you look at everything and in closing arguments, they'll be able to wrap it up.
Now, Brian, the defense noted that many of the interviews were not recorded at all. So why is that specifically important?
It's an argument about reliability, because what you're saying to the person who you're cross-examining is you are giving this jury what you remember of happening on that day. The better version of what we could have had is if it was recorded. I mean, even go to like the credit card use, right? Okay, you are telling the jury what you remember from years ago when you did an interview. You're not giving us what is word for word. And with someone like Little Dirk, his credit card is used by many people. He's a famous person. I mean, think of like even in your own house. Like when I have weird payments that come up and be like, hey, maybe it's the 4-year-old who bought that new suit for Dad. And it's not me, sweetheart. Like I can't control when the 4-year-old buys custom suits for his dad. Like what? It's the same reason why it doesn't work, but it's an argument that still is used in many places.
All right. Now, this trial's going to move on. What are you looking forward to in it?
I think, again, with Little Dirk, similar to the Keffe D, it's about corroboration. And also I want to see more than just a cell phone was close by and a credit card was used, because with people like this who have cell phones registered to them, their cell phone might not always be on them, on their person. It might be with a friend or whatever it is, because you're taking care of other people. Same thing with a credit card. Show me a video, show me concrete that says Little Dirk is a part of this, not just a paper trail.
All right, and Bernardo, what are you looking forward to this trial goes on?
I want to see the cooperators. I want to see how they do on the stand, because the cooperators are going to be the eyewitnesses against these defendants. That's it. Because we know in terms of the shooting itself, it was 2 shooters, but we know that Little Dirk wasn't physically there firing the gun.
All right, we'll see. Bernardo Villalona, Brian Buckmeyer, it's a pleasure as always. We'll do this again soon tomorrow, all right? And thank you for joining us. I'm Micah Giacchi. We'll be live weekdays with new episodes right here on ABC News Live at 5:30 p.m. and 8:30 p.m. Eastern. And if you missed any of today's episode, you can check it out on demand on Disney+, Hulu, or wherever you listen to podcasts by searching Burden of Proof.